It should be, I can start it.
Yeah. When you're ready to start, Professor, can you go to the podium?
No.
Great. Yeah. But Professor Huberfeld, can you hear me? Oh, yeah. Great. We can see you.
I can hear you, thank you.
Oh, amazing. Okay, great. So I'm very excited to introduce our speaker today, Professor Nicole Huberfeld. She's a visiting scholar at the Petrie Sloan Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School. She's also the Edward R. Atley Professor of Health Law at Boston University, with a joint appointment at the law school and at the School of Public Health. Professor Huberfeld's work is at the intersection of health law and constitutional law, and more specifically, she primarily writes on the role of federalism in healthcare. Her work has been cited by the US Supreme Court and other federal courts and state courts. She is the author of 2 books on health law, as well as dozens of law journal and peer-reviewed articles. She was quoted in articles published in the New York Times, Washington Post, NPR, The Guardian, Politico, Boston Globe, and Stat News, among others. In 2025, she won the Boston University School of Public Health Faculty Award for Excellence in Research and Scholarship, as well as the DO Award for the Department of Health Law, Policy, and Management. Today, Professor Huberfeld will speak about one of Congress's powers, the spending power, and the way in which it influences the funding of healthcare in this country. Professor Huberfeld, we are very, very excited to learn from you today, and the metaphorical floor is yours.
Thank you so much for that really lovely introduction, and I'm not looking at anything, and so I'm hoping that everybody can hear me. Oh, there we go, now I can see people in the room, wonderful, thank you. Thank you so much for having me. Thank you for this wonderful invitation. Thanks to Sharona Hoffman and everybody in the Case Western Law Medicine Center faculty and everybody else at Case Western. And thanks to Eric Seiler for all of his administrative work in bringing this together. It was quite prescient of you to make this a virtual talk. We have about 2 feet of snow on the ground here in Boston right now, and we are still digging our way out. There are mounds of snow as tall as I am, and I'm not a very big person, but that still means that they are higher than 5 feet tall. So I hope that you all are well and safe in this crazy, blustery, wintry weather. And also thanks to the students who are in the room. It's always nice to have some live faces, and I look forward to your questions and your comments, both from people in the room and online. Thanks for joining today. So without further ado, I would like to dive in and thank you for indulging me in sharing work that is the culmination of about 2 years of research and writing. It was actually just live on the Yale Journal of Health Policy, Law, and Ethics yesterday in the afternoon, so totally fresh and hot off the press. And so I'll go ahead and share my screen, and we will get started. Hoping everyone can see this, yes? Thumbs up? Okay, great, thank you. Let me just hide my floating meeting controls so I can see better as well. Okay, wonderful. So, as you heard in the wonderful introduction, I have spent more time than most people thinking about the spending power, the nature of federalism, and how we structure health care and public health programs in the United States. And in this paper, what I want to explain to you and to everyone is that healthcare has become a vehicle for constitutional change all over again. And when you hear that, you might think about decisions like the Dobbs decision overturning Roe v. Wade. If you are in the camp of people who think abortion is healthcare, then that would certainly come to mind, and rightly so. However, what I'd like to convince you is that there's something much bigger happening in terms of tensions between the federal government and states and the way that they are fighting for power over regulation of medicine and public health in the United States and the kinds of implications that will have for not just healthcare and public health programs, but for all social programs. And so what I'll do is I'll talk just a bit about the spending power to ground us in it, because I know not a lot of people spend much time thinking about the spending power after they've learned about it in constitutional law in their first year of law school, and show you that there are through lines that we should be aware of here, where states are testing the new Roberts Court, what I call the new Roberts Court, meaning the Supreme Court's composition after Ruth Bader Ginsburg with the addition of Amy Coney Barrett and the some kind of shift in the middle toward the right on the Supreme Court since Ruth Bader Ginsburg passed away. And the way that states are purposefully taking advantage of the shift in the court's leanings, interests, and canons, if you will. So we'll talk a bit about the spending power and ground you and how it operates, why it's important. Talk a bit about how the states are testing the new Roberts Court on the spending power. Show you that I have created a taxonomy for understanding the different theories that states are bringing up repeatedly before the court. And then talk a little bit about what I think the implications are for this rash of litigation across different kinds of healthcare programs, because it really is remarkable once you start paying attention to this phenomenon, how much has the potential to change if the court is open to the arguments that I perceive here. And I also will further argue that there are 3 recent Supreme Court cases that show us that the court is indeed not only open to the arguments that states are making, but starting to change spending power doctrine. So, tiny topic, not much to say. We've got a lot of ground to cover in the next 40 minutes or so. But again, I look forward to your questions and comments at the end. So again, in case you're not really thinking much about the spending power, I always think it's good to begin with the actual words. This is the General Welfare Clause, Article 1, Section 8, Clause 1. Congress shall have power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and general welfare of the United States. And so sometimes this is referred to as the General Welfare Clause. It's also the clause that contains both Congress's taxing power and its spending power. And so though the word spend is not specifically within this language, the word provide was commonly understood to mean spend. Because obviously, if Congress is going to be able to tax different things, people, right, then Congress would need to be able to do something with that money. And so there was a debate amongst the framers as to what the meaning of the spending power would be. This was a debate between Madison and Hamilton in particular that was resolved in the 1936 decision, U.S. versus Butler. In that decision, the U.S. Supreme Court, for the first time in our history, if you can believe it, had an opportunity to resolve this debate between the framers as to whether the spending power simply was a way to expand other enumerated powers for Congress, or whether the spending power was itself a plenary power for Congress. The Hamiltonian view was that it was a plenary power, and that's the view that won the day. So in U.S. v. Butler in 1936, the Supreme Court adopted the Hamiltonian view of the spending power and said, yes, this is a singular, plenary, complete enumerated power for Congress. And so until that time, the spending power wasn't as meaningful as you might think, because it took the 16th Amendment, which became part of the Constitution in 1913, to make it so that Congress had a meaningful amount of money to start to influence policy and behavior through spending in really big ways. And so once the 16th Amendment created a federal income tax, then Congress had more money to use to influence policy nationwide. You also have to remember, again, for a little bit of historical literacy, that before Congress created all of these different kinds of spending, it created the Social Security Act. And the Social Security Act is actually the federal law that was amended to create programs like Medicare and Medicaid. And so, and again, if you're not intimately familiar with Medicare and Medicaid, remember Medicare, Care for the Old, it's the program that everybody gets into when they turn 65. It's public health insurance. Medicaid is our program for people who are low income. But the spending power has been used to create not only Social Security, Medicare, Medicaid, but also all of the sub-agencies within the Department of Health and Human Services, including CDC. It also is, funding for food programs, meaning the USDA subsidies to farmers, but also programs like SNAP that help people with food insecurity. And the spending power has been used to influence behavior in different ways. So, for example, the Civil Rights Act of 1964 contains Title VI, which says no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or subjected to discrimination under any program or activity receiving federal financial assistance. So the spending power has been used not only to create national programs that are supports for different populations, or even the entire population in the instance of things like Social Security and Medicare, but also has been used to further anti-discrimination goals. Title IX is another example of that. So the spending power is Congress's biggest source of indirect power, because it is everywhere. Once you start paying attention to it, you realize that federal funding is used for many, many different kinds of national policies, but it is especially abundant in healthcare and public health. And most of the time, when Congress chooses to spend, it does so with the help of states, creating what we think of as cooperative federalism programs, meaning states are invited to partner with the federal government. They get federal money for that partnership, and in return, they're expected to abide by federal rules. That's how Medicaid works. Medicare, on the other hand, is a purely federal program. It doesn't rely on states. Instead, it relies on private contractors who are responsible for the payments in Medicare and things like that. But Medicare is the exception. Most of our healthcare and public health programs are cooperative federalism programs that rely on conditional spending. Now, I mention these things because when we think about how much we rely on conditional spending, it's important to recognize that this cuts all the way across healthcare in the United States. And I'm always reluctant to use the term healthcare system because we don't have a system for healthcare in the United States. It's a non-system. If we were designing a system, it would not look like this. However, federal funding and conditional spending cut across healthcare in the United States, and in fact, it's Medicare that created the Universal Access to Emergency Care rule that we know as EMTALA, the Emergency Medical Treatment and Labor Act. EMTALA is a condition of participation in Medicare that says that all hospitals with emergency departments must either treat or stabilize anyone who shows up with a medical condition, regardless of their source of payment, because that hospital takes Medicare funding. So again, that is conditional spending. Okay, so hopefully you get the idea that the landscape in very broad brushstrokes, and the way the court has evaluated conditional spending since 1987, this has been the test we call the Dole test from South Dakota versus Dole. The court says exercises of the spending power must be in pursuit of the general welfare, conditions must be unambiguous, the conditions have to be related to the federal interest in the particular national program, and other constitutional provisions must not provide an independent bar to the conditional grant of federal funds, meaning Congress can't say, we'll give you this money if you give up your First Amendment rights. We'll give you this money if you waive your Eighth Amendment right not to be subjected to cruel and unusual punishment. So what the court did not say in Dole was that the 10th Amendment played a role in evaluating conditional spending. And the 10th Amendment reminds us that if Congress isn't given enumerated powers, then powers are reserved to the states for their exercise under their police powers. So the Dole test has been the gold standard for understanding when conditions on spending are constitutional. The court has taken a pretty broad view of what Congress can do with conditions on spending. And in fact, for a long time, most of the action was in this second prong of the Dole test. Conditions must be unambiguous. In other words, if a state or private party is taking federal funding, it needs to understand unambiguously what it is supposed to do with that money, what the terms are, what the conditions are. So the second prong of the Dole test has been where most of the action is since 1987. And this was true even during the so-called Rehnquist federalism revolution. The Rehnquist court initiated what many people called the federalism revolution by placing limits on Congress's commerce power. However, even during this time period, when we had cases like U.S. v. Lopez in 1995, when the Supreme Court, for the first time since the New Deal era, said that Congress had exceeded its commerce power in creating the Gun-Free School Zones Act, the court still found the spending power to be convincingly broad and was largely unconcerned with whether it could be a doctrine that implicated federalism or state sovereignty. And so during the Rehnquist Court's federalism revolution and into the early days of the Roberts Court, quite commonly you would see this preambular language where the court would write, if it had any kind of spending power question, Congress has broad power under the spending clause of the Constitution to set the terms on which it disperses federal funds. This preambular language is in nearly every spending power decision from 1987 forward, and it shows you that the court didn't see the spending power as a threat to federalism principles even during the federalism revolution. However, today, if you are tuned in to the Supreme Court, even last week, you would have heard spending power questions arise during oral arguments that seemingly had nothing to do with the spending power. So last week, there were oral arguments in 2 Title IX cases, questions about whether trans people can play sports in the gender of the gender that they identify with. And in West Virginia versus BPJ in particular, these were the Title IX arguments as opposed to the case out of Idaho, which implicated the Equal Protection Clause more directly. And during these Title IX arguments, Justice Thomas says, in interpreting this definition, meaning the definition of sex, would it make a difference, or does it make a difference, that this is a spending clause statute? Now that you're tuned into this, if you're ever listening to oral arguments with this Supreme Court, you're going to hear the spending clause come up again and again. And here you have Mr. Williams responding on behalf of West Virginia. I think it absolutely does in the spending clause context, as this court has somewhat recently reminded lower courts, meaning the 3 cases I'm going to talk with you about. It's important for Congress to speak with an even clearer voice, because of the contractual nature of the conditions that are imposed. States like West Virginia have to understand exactly the obligations that they're assuming in the context of a spending clause analysis. Effectively, this is a canon of construction that requires a clearer statement in order for the condition to attach. So what are we seeing here? We're seeing the development of stronger, clear statement rules than we have seen the Supreme Court demand from Congress in the past. Clear statement rules are a canon of construction where the court effectively says to Congress, if you don't use the words in the statute, we are not going to give you or the agency implementing the program the benefit of the doubt. We are not going to say we think that this condition is valid under the spending power. Now, given that I just told you during the Rehnquist Court and the early Roberts Court, you might think, well, that seems like a real sea change. What happened? Well, first of all, what happened is NFIB versus Sibelius. So let me get there in just a second and explain to you how we got to this chart. This chart represents the litigation that's occurring in federal courts where there are healthcare-related subject matters where states are raising spending power arguments in conjunction with arguments where they claim that they have carte blanche over regulation of medicine. So I know that's a little bit hard to tease apart. I will explain what I mean here, but I think it's important to understand that there are these sort of parallel arguments going on. One side of this parallel is that states are arguing when there are conditions on spending, we don't necessarily have to abide by them, either because they were not clear enough and we didn't understand them, they weren't related enough to the reason that the spending program was created, right? That's that third prong of Dole. And or, if they weren't clear enough, then we are being coerced by the federal government and therefore they are unconstitutional conditions on spending. Further, states are arguing the 10th Amendment is a limit on conditional spending, and it's a limit especially after Dobbs, because Dobbs said no fewer than 7 times, we're returning this issue to the people and their elected representatives. So in returning the issue of abortion to the people and their elected representatives, states see that they have this sort of surge in power to regulate medicine, and they are trying to claim dominance over regulation of medicine. And so across different subject matters, we see these same kinds of arguments time and again. So in Health and Hospital Corporation versus Talevski, which is the first of the three cases that I wanted to mention to you today, here what we had was a set of arguments regarding whether federal rules for nursing homes could be enforced in federal court against non-compliant states under the civil rights law called Section 1983. Now, Section 1983 rights of action have made it so that healthcare providers and patients who are paid by Medicaid have had the ability to force states to comply with Medicaid rules. This has been the case since 1980. However, states have been trying to claim repeatedly that 1983 rights of action are not available to enforce Medicaid rules against states. They kind of gave up on this set of arguments for a while, and to the point where I was thinking I didn't even need to cover Section 1983 in my books. But then the petition for certiorari was granted in Talevski, and everybody thought when the court was hearing Talevski that the court was going to narrow or eliminate the circumstances in which 1983 actions could be used to force states to comply with federal rules in Medicaid. It happens in Talevski that the word right is used in the Nursing Home Patients Bill of Rights, and so in this case, the court had a strong majority that said, we think that when the word right is used, Section 1983 civil rights can be enforced in federal court. But there were concurrences and dissents, which I'll show you in a moment, where members of the court said, yeah, we think this is a pretty clear case, but we want to see other spending power cases. We want to reconsider this idea of whether Section 1983 is available to enforce conditions on spending against states. Sure enough, states kept coming, they kept testing, and that's what we get in Medina versus Planned Parenthood South Atlantic. Now, some of you may be thinking of this as an abortion case. It's the case where South Carolina excluded Planned Parenthood as a provider in Medicaid, even though Medicaid almost never pays for abortions in the program. It has to only fit the rules of the Hyde Amendment, so that if a person's life or health is in jeopardy, then they might in fact have Medicaid pay for their abortion. But in South Carolina's case, they decided to totally exclude Planned Parenthood unless they stopped providing abortions entirely. So the claim by providers and patients in South Carolina was, you're violating the any willing provider provision in Medicaid, and historically that provision was enforceable through Section 1983. But in Medina, the Supreme Court decided it was no longer enforceable through Section 1983. Then there's also the EMTALA case that the court heard 2 terms ago, Moyle versus US, which is now morphed into St. Luke's Health System versus Labrador since the Trump administration has withdrawn from the ongoing litigation. Even though the Supreme Court decided that this was improvidently granted and tossed it back to the Ninth Circuit, what was happening in this case was somewhat extraordinary because the state of Idaho was claiming that its criminal law outlawing abortion in nearly all circumstances except to prevent the death of the patient superseded the federal law that is EMTALA, which makes it so that, as I said earlier, you have to treat or appropriately transfer anyone who comes to an emergency department, and EMTALA specifically makes it so that treating a medical emergency includes not just life, but health. And the history of EMTALA shows that Congress made this choice purposefully. It was not an accident that you are working to stop people from being dumped to preserve both their health and their life. So there's a conflict between the federal law, Medicare, and the state law, which criminalizes abortion. And again, what we see here is the state of Idaho and states and advocacy groups supporting it, trying to claim that they don't have to abide by this federal law because it was enacted under the spending power. Same kind of thing in the FDA mifepristone cases, same kind of thing in the ACA Section 1557 gender-affirming care cases. What you're seeing in these cases is a claim that the ACA Section 1557, which is a civil rights portion of the Affordable Care Act, makes it so that healthcare providers cannot discriminate on the basis of sex. There's been a big fight going on about what sex means in Section 1557, and states are claiming, well, we get to decide what sex means, and we don't think it means gender-affirming care, and you can't make us cover gender-affirming care under Medicaid because we didn't have clear notice, and therefore we're coerced. Okay, so you get the idea. One thing that's interesting about this pattern, and again, it occurs across different kinds of health laws, is that it is now being turned on its head by progressive states. So all of this litigation that I was talking about before arose during the Biden administration and was brought by what we might think of crudely as red states. However, during the second Trump administration, blue states are starting to run with these arguments as well. And for example, one context in which that is occurring is in Planned Parenthood Federation of America versus Kennedy and California versus Kennedy. These are parallel tracks of litigation trying to challenge the defunding, the one-year defunding of Planned Parenthood in Medicaid under H.R. 1, or what some people call the One Big Beautiful Bill Act that was enacted on July 4th of 2025. So we now see progressive state attorneys general kicking up the arguments that were made by conservative states attorneys general during the Biden administration and making the same kinds of arguments that they didn't have clear notice of this condition, that they're losing money and it's going to be impossible for them to make it up, and that they're being coerced. So we see the same kinds of arguments being made now during the second Trump administration. And so, as I said before, there's through lines here, and I don't want to run out of time. I know that's a lot of background for you, but in the paper, I'm very careful to trace these through lines because I think it's really important to document what's happening right now. That these are not new arguments, but rather arguments that started during the Rehnquist Court's federalism revolution, but the Rehnquist Court just chose not to take them up. And you see this in concurrences and dissents during the Rehnquist Court era. You would see, for example, Justice Kennedy saying things like, well, I don't understand why we're not treating the spending power like the commerce power. We should be considering whether it should be limited so that we're not running afoul of federalism principles and honoring state sovereignty. And then states successfully ran with these ideas in the very first case against the Affordable Care Act, NFIB versus Sebelius, where states very successfully argued that they were being unconstitutionally coerced by the federal government in the expansion of Medicaid eligibility under the ACA being a mandatory element of Medicaid. This was the first time that the Supreme Court made coercion a live doctrine. Until that point, it had simply been dicta that arose in South Dakota versus Dole. So in NFIB versus Sebelius, we get the court saying, yes, we do think there's such a thing as unconstitutional coercion. It isn't what we saw in South Dakota versus Dole, where a state would only lose 5% of its highway funding if it didn't enact a 21 drinking age, but we do think it exists here with Medicaid expansion, where a state could theoretically lose 100% of its Medicaid funding if it doesn't comply with the mandatory expansion of Medicaid eligibility under the ACA. Now, it didn't matter to the court that no state had ever lost all of its funding, that losing funding would actually harm healthcare providers, patients, and states, that HHS always takes a more conciliatory route when a state is non-compliant. None of those facts on the ground mattered. The court recognized the coercion doctrine, but also didn't tell us what lies between 5% and 100%. And that's why I had a picture of velociraptors at the beginning of the slides, because the velociraptors are testing the fence. If you remember your Jurassic Park, right? The velociraptors are testing the fence. In this analogy, the velociraptors are the states, the fence is federal law. Because states have been trying to get the Supreme Court to take up coercion arguments since 2012. The Roberts Court has taken a turn toward formalism that, as I said before, makes it so that clear statement rules are much more dominant in their analysis. And you see this not just specifically in the spending power context, but also with the rise of doctrines like the major questions doctrine. We also could argue that, for example, getting rid of the Chevron doctrine and Loper Bright is a function of this turn toward formalism, where if the words are not on the page, the court doesn't want to hear your arguments. But it's also, I would argue, and I do argue in this paper, a function of post-Dobbs state empowerment, that states now really see themselves as having carte blanche to regulate medicine however they want to, whether it's evidence-based or not. So in the paper, I tease out what's happening across the different briefs in the various cases that I showed you in the chart, where there are some really, really pretty radical theories that are arising across the briefs. I think they are not really likely to become live doctrine, but it is notable unto itself that some of these theories are gaining traction with at least 2 or 3 of the justices on the Supreme Court. So I named the theories in the paper. I organized the theories and named them just so that it's easier to keep track of what they are. So this is just me giving things names because it's a helpful way to think about what's happening in all of this abundant litigation that states are bringing. So first is what I call the negation theory. And the idea here comes from one scholar who wrote in the 1980s, David Engdahl, in the 1990s, I should say, and then more recently, Philip Hammerger. They argue that the General Welfare Clause contains a power to tax, but it doesn't really have a power to spend, that there is the ability of Congress to spend the money that it does collect from taxation, but it cannot place meaningful conditions on the power to spend. In other words, there's no such thing as regulatory conditional spending. So I call this negation theory because it would totally blow up everything we've understood about the spending power really since US versus Butler. I don't think the negation theory is going to gain traction with the majority of the justices. It would be really radical to totally change the way the court interprets the spending power. But in Talevski, that first spending power case that I mentioned to you, which was a question of whether Section 1983 can be a vehicle for enforcing conditions on spending against states, Justice Thomas wrote an extensive dissent explaining his viewpoint on the negation theory and borrowing from Engdahl and Hammerger's work. It's like a manifesto for why there's no spending power. The second theory that I named in the paper is what I call the lesser spending power theory. And so this is slightly less radical. The idea here is that the spending power is different. It's different from other enumerated powers. It doesn't function the same way. It's a limited enumerated power for Congress, not a plenary power. And so therefore, Congress's regulatory authority is constrained under the spending power, and it doesn't have any preemptive effect. Remember what I was talking about with Moyle, right? The idea there being that if EMTALA does have preemptive effect, then Idaho's criminal abortion ban doesn't override the obligation to treat people who need medical care in emergency departments. But some justices agree with Idaho that if a state doesn't have a totally clear path to understanding what is required from federal law, then that federal law doesn't preempt state law. So the lesser spending power theory is still pretty radical, but not as radical as the negation theory. Third is the maximal clear notice theory. This is already underway, quite frankly. This is already happening. So what we see here is the justices are starting to amplify what are called clear statement rules. They're demanding extreme precision in federal statutes, and they want conditions on federal spending to be clear and unambiguous. And this is language that Justice Alito wrote into his decision called Arlington Central School District versus Murphy in, I think, 2006. And so what's happening is that putting the Arlington language together with NFIB versus Sebelius, states are arguing, as I said before, that if we don't have clear statements of what the conditions are, that second Dole prong, then we are coerced. NFIB versus Sebelius, right? Finally, we have the limited private enforcement theory. And again, because of Medina, this is already happening. Private parties cannot enforce spending statutes against non-compliant states in federal court unless a right is explicit within the federal statute and never under Section 1983. So this is the limited private enforcement theory. So let me just show you a couple examples of how this is coming about, and then I'll talk about implications. So as I said before, Justice Thomas really ran with the negation theory in his dissent in Talevski. And it's just a dissent, but he does this thing where he writes a dissent and then cites his own dissent repeatedly. And so chances are good you're going to see this dissent come up again and again in spending power cases and conditional spending cases specifically. So in this dissent, Justice Thomas wrote, an exercise of Congress's spending power, whether it comes from the so-called spending clause or elsewhere in the Constitution, and there he's referring to Engdahl's theory that the spending power actually comes from the property clause, not the general welfare clause, is no more than a disposition of funds. As such, a conditional exercise of the spending power is nothing more than a contractual offer. So he's effectively saying spending programs are not the same as other federal laws, and in his view, conditional spending doesn't have the same effect as federal law. It is just a contract between the state and the federal government, or the private party and the federal government. So this, again, is a pretty radical idea, because it would completely change the way that we understand how spending programs work. As I said before, I don't think it's likely that that will gain traction with the majority of the justices. Even Justice Alito, who has been driving many of the opinions where the super clear statement rules are required, did not join in Justice Thomas's dissent in Talevski. And he did dissent separately in Talevski, so he was certainly thinking about what the case really meant, but he didn't join Thomas in that dissent. Under the lesser spending power theory, we can include language from Talevski, from Medina. Justice Gorsuch wrote in his concurrence in Talevski, to my mind, there are other issues lurking here. The petitioners failed to develop fully whether legal rights provided for in spending power legislation like the Act are secured against states in particular, and whether they may be so secured consistent with the Constitution's anti-commandeering principle. That's a principle that goes along with coercion, which I described when I was talking about NFIB a moment ago. And then in Medina, Justice Gorsuch wrote the majority opinion, which did in fact limit Section 1983 rights of action for Medicaid providers and patients. And note how he wrote this. When Congress passes a law, say, regulating commerce between the states or outlawing piracy, it can point for authority to the Commerce Clause or the Piracies Clause. In enumerated areas like those, the Constitution vests Congress with the power to regulate conduct. But when Congress distributes money, its authority rests on a different footing. The Constitution has no spending clause, strictly speaking. Instead, we usually trace Congress's spending power to Article 1, Section 8, Clause 1. Unlike other enumerated powers, this provision does not expressly endow Congress with the power to regulate conduct, nor does it include the power to issue direct orders to the governments of the states. And so this sort of is close to negation theory, but in the paper I argue that it isn't quite. He didn't join again Thomas's dissent in Talevski, but you can see the influence of Justice Thomas's dissent in this language saying, I'm not sure the spending clause is what we've been saying it is since U.S. versus Butler, and in fact, I'm not sure I agree with the Hamiltonian view at all. We saw Justice Barrett bring up the same kind of language in Moyle, and Justice Alito's dissent also in Moyle, kind of questioning what the nature of spending clause legislation is. Now, their views were not quite as extreme. And these, again, in creating this taxonomy, the idea wasn't to create silos or bright lines, but rather to organize the somewhat disorganized arguments that states are making across health law litigation. Probably more important for our conversation is the maximal clear notice theory, again, because the court is already engaging in this kind of analysis. It is already demanding clearer conditions on spending. So you see this in the Jackson majority in Talevski in footnote 8, right? She first calls out HHC, the nursing home that didn't want to abide by Medicaid rules, because the state of Indiana made really radical arguments that were closer to the negation theory, basically saying there's no such thing as the spending power, and if there is, we don't have to abide by it. And the court rejected that idea. But you can see here Jackson is saying, basically, I don't like your bait and switch. You're telling us there's no such thing as the spending power, but if there is, you don't really have to abide by it under Section 1983. So she plays along and says, yes, it's a well-established requirement that Congress must have unambiguously conferred a Section 1983 enforceable right in a spending clause statute. And here, what we see in the Federal Nursing Home Reform Act is that HHC did have clear notice. So, in other words, she's saying, even if this is the rule that there is extreme clear notice, HHC had it. So she kind of plays along. But then you see, too, in Alito's dissent, he's like, I'm not going to play along. I don't think that there is access to federal courts here. I think you have to use state administrative processes. And I want to see unambiguously conferring individual federal rights to create rights within the meaning of Section 1983. So this maximal clear notice theory is already being successful. It's already seen success at the Supreme Court. Same thing in the Medina Gorsuch majority. Because spending power legislation is in the nature of a contract, the grantee has to voluntarily and knowingly consent when there's going to be Section 1983 enforcement. And here, what we don't see is the word right being used. And so Gorsuch is effectively doing what the court has done in other such cases, which is to say, Congress didn't create this statute clearly enough, and it doesn't really matter how interpretation of the law has evolved over time, we're going to stop this train. So even though Section 1983 rights of action have been available for certain provisions in the Medicaid Act since 1980, that is now going in reverse because of Medina and the way that states are arguing these cases. Same thing in Moyle, you see this in Alito's dissent, right? And so this goes on and on. And I don't want to read all of these quotes to you, I don't want to bore you with it, but the proof is there. Please trust me when I say the proof is there in the court's very own words. This is not just a matter of what you see in the briefing, but also, if you're attuned to it, what you see in the court's very own words. And again, for that fourth theory, the limited private enforcement theory, it is already coming to fruition. So under the Talevski case, what we see in Justice Barrett's concurrence, right, as the court explained, Section 1983 actions are the exception, not the rule, for violations of spending clause statutes. So she's basically saying we're not as open to these kinds of private rights of action as we have been in the past. Same thing in the Medina Gorsuch majority opinion. So when we're thinking about these four theories and why they're important, I think it's helpful to break it down into three categories of possibility. There are doctrinal, theoretical, and pragmatic implications for what's happening here. So first, what we have is potential shifts in the scope, interpretation, and enforcement of long-standing social programs. And in part, this is because the court doesn't seem to be too concerned that it is changing the rules of the game for programs that have been around for 60 years. Medicare and Medicaid were created in 1965, and rules have evolved over time, both as a function of judicial decisions, but also as a way for Congress and the states to negotiate the cooperative federalism aspect of our social programs, our health law programs. And so I think we need to recognize that states, if they're successful in advancing these theories even further, may not necessarily get what they want. In other words, they may be kind of like the proverbial dog who caught the car and then doesn't know what to do with it. Because there could be a bunch of different federal responses here. If the court continues to hold that there are sort of maximal clear statement rules that are required of conditions on spending, Congress could respond in a number of different ways. Congress doesn't have to keep giving a lot of money to states for Medicaid, for example, but not have so many rules. And in fact, the rules in Medicaid exist for reasons that are related to the fact that states have done what they were not supposed to with federal money. So the reason those rules exist in the first place is that states have proven they can get a little too creative with federal funding. So Congress could decide that it wants to federalize cooperative federalism programs, right? It could decide we're just not going to act with states anymore. It's actually constitutionally more straightforward not to have cooperative federalism, as Justice Ginsburg pointed out in her dissent, 95B versus Sebelius, right? Medicaid is complicated, and part of the reason it's complicated is that the federal government relies on states to implement it, and if they don't, then that part of Medicaid doesn't exist in that state. We still have 10 states that have not implemented Medicaid expansion, for example. So Congress could choose to federalize programs like Medicaid. It could cap longstanding federal programs, right? It could offer more expansive federal coverage with more federal rules and less for states to do. Or it could just abandon federal programs and say, you know what, states? Here you go. We're not going to deal with Medicaid anymore. Medical welfare is yours, right? Good luck to you. Because the truth is, states have needed federal funding for programs like Medicaid since the Great Depression. They cannot create these programs on their own. So the possible federal responses, A, are not obvious, and B, may mean that states don't really achieve the desired increase in power or sovereignty that they think they might, depending on the federalism values that they're expressing in the briefing to the courts. Because the states may get less than they want. They may get less money, they may get no role in the program. It really depends on how Congress responds. And though in historical terms, we would say that social programs like Medicaid, like Medicare, have had the impact of improving anti-discrimination and anti-subordination goals, HR1 is telling us a different story. HR1 has placed important limits on the Medicaid expansion population by codifying what may happen with work requirements. And so states are now going to be required to implement work requirements that will disenroll millions of people from Medicaid. This is a retrenchment that I think is important for us to take into account when we think about what Congress might do in response. Another possible implication here is that those states may have short-term political gains if, legislators and state attorneys general are arguing that they shouldn't have to comply with federal conditions on spending. Yes, they may have political gains from that. That might sound appealing to the people who have elected them. However, there are long-term financial risks that they're really not explaining or facing in making these arguments, because the kinds of sort of crystallized dual sovereignty federalism arguments that the states are making in these cases assume that states are both better at creating and better at being responsible for social programs. However, states lack the fiscal capacity to implement the very programs that they are seeking to limit. And this is true across the political spectrum. So even though a state like Massachusetts isn't making these arguments that they want less funding and less rules until PBFA versus Kennedy, on the other hand, Massachusetts was the first state to have meaningful universal health insurance coverage, and that relied on the Medicaid waiver. So even wealthy states that are health policy forward rely heavily on federal funding to implement their chosen health policies. So yes, it's possible that states will have some political gains, at least intra-state, in terms of being able to argue that they successfully fended off the federal government and its many conditions on spending. But states need federal funding. They especially need federal funding when there's an economic downturn, a public health emergency, a natural disaster. They rely on federal funds to bolster countercyclical spending. We just saw this during COVID-19. And every state has rules regarding balanced budgets. And so if states don't have that federal funding to fill in the gaps when there's a significant downturn, people will suffer. Finally, the last big implication is civil rights retrenchment. As I said before, the kinds of rules that have come with conditional spending, like Title VI, like Title IX, have anti-discrimination and anti-subordination valences, and we can see the kinds of arguments that are being made in these cases, at least during the Biden administration, as having a pretty strong anti-safety net valence. And so, yes, spending programs historically have protected civil rights and reinforced them. Medicare was responsible for desegregating hospitals through Title VI of the Civil Rights Act of 1964. But again, if we point to legislation like HR1, it's not a guarantee that conditional spending will protect civil rights going forward. Finally, it's also worth noting that the limitation of Medicaid private rights of action to ensure that states are acting in Medicaid in the way that they're supposed to has implications beyond Medicaid, because Section 1983 is important for access to justice and has been since the Civil War, nearly. So let me stop there and make sure that we have time for some questions, and thank you for being great listeners.
Thank you so much, Professor Huberfeld. We will now see if we have any questions from the audience. I myself have questions, but I would like to give opportunity to either our participants in person or online, if there's anyone who would like to ask. Anyone online? Okay, great. So yes, I have my opportunity to ask my questions. So I guess I'll ask two questions, and maybe you'll decide which one of them is better for you to conclude with. So one question is predictive. And my question is, what do you think is going to happen, either in terms of how Congress responds to these developments, or how do you evaluate the chances of these new initiatives by so-called blue states to turn these developments on their heads and challenge recent federal legislation? The second question is explanatory. We have some contracts students here in the room, and we saw in maybe each of your theory there was a reference to a contract. The justices referred to contract, and I guess maybe we're wondering, I mean, when I imagine contract, I imagine two private individuals. So what is it, this contract that the justices were referring to in this context?
Yeah, those are great questions. Thank you. So we take the first one first. What do I think will happen? You know, there has been a lot of, I think, very good, strong critique of the court's crystallization of the coercion doctrine in NFIB versus Sebelius. Uh, as I said before, the court really didn't tell us what lies between losing 5% of available federal funding and 100% of available federal funding. And the court didn't really take up the, I think, important idea that it matters how much money is being offered as well. Because if Congress were offering states $1,000 to implement the Medicaid program, it would be laughable. So even if they could lose 100% of that funding, you know, no state is going to be coerced by the offer of $1,000 and the possibility of losing $1,000 for a program that costs billions of dollars to implement, right? So the coercion doctrine unto itself is incomplete. And I think the attempts to try to get the court to put meat on the bones of the doctrine will continue because it's just lying fallow, but it seems ripe with opportunity. And I think it seems to me the coercion doctrine will never be clearly administrable by federal courts. Because what isn't being taken into account in either the sort of extreme clear notice, the maximal clear notice rules, or in the arguments for coercion that are getting tacked onto that, is the fact that these are long-standing federal programs, and they don't, technically, a state agrees every year to keep doing Medicaid, right? But not really, because states assume that money will be there when they're creating their budgets every year, and states do have to create budgets every year or every 2 years, depending on the state, right? These annual decisions that are made by states as to whether to continue these health policies always count on that federal funding being there. So there's something to be said for the historic longevity of some of these social programs that are part of the fabric of our national policy, and how damaging it could be for the court to say, that's not what that means anymore. I think it's very hard to say what Congress would do with that. And let me add to it, it gets even more complicated when you consider that there are justices who are just totally uninterested in legislative history. Because legislative history shows us that EMTALA was purposefully written to include both health and life for emergency medical care, right? History also shows us that Congress did consider whether to change or exclude private rights of action from Medicaid, and rejected that idea repeatedly. Congress knows Section 1983 is used to enforce historically required resolution at the federal level, constitutional resolution and statutory resolution at the federal level. And so I don't know what it looks like for Congress to engage in that kind of resolution in an era when Congress is considered by political scientists to be more slow-acting and less functional than usual. I mean, Congress is designed to be slow, right? That we can all sort of think back to our civics lessons and our understanding of why we have separation of powers and checks and balances and all that, right? Congress is designed to be slow. Lawmaking is designed to be slow. Nothing happens in our federal government with two branches acting in both circumstances, right? That's all purposeful. But we do seem to be slower than usual and more dysfunctional than usual. So I think it's a great question and very hard to answer. I don't have a magic 8-ball to tell me the answer on that one, unfortunately. I think it makes it so that it creates a kind of confusion. It makes it harder for people to understand what the status of the law is. It makes it harder for regular people to make use of existing law, especially when policies are articulated in a haphazard fashion by legislators and other policymakers. So I think that it makes it so that, when you see numbers dipping for things like enrollment in the exchanges, it's not just because the Trump administration cut funding for navigators. It's also because people are confused when leaders badmouth existing laws and they don't know what it means, right? So there's this sort of soft aspect to it as well, this sort of creation of public confusion that makes it harder for people to understand what the law actually means for them, that the ACA is still a law, that they do still have Medicaid coverage, that they do still have health insurance exchange coverage, you know, things like this. So great question, very hard to predict though.
Really great. Thank you for an illuminating talk. Please join me in thanking Professor Uberfeld. Thank you so much.
And to those who are looking to get CLE credit for this, the activity code is in the chat, and the number is 608514. And please see this PowerPoint presentation that will be up shortly for additional information. Thank you all for coming.
Thank you so much, Professor, again.
What were you going to ask? I was going to talk about Ex parte Young, an alternative to 1983. Oh, yeah. I didn't get my hand raised in time.
There it goes sometimes.
Yeah, it's...
Yeah. How you doing, Nick?
I'm good, how are you?
I'm doing well. You have a nice snow day yesterday?
I did, it was very, starting to get a little
Thank you,
cabin
Rob.
fever over the weekend, but it's still good.
Mm-hmm.